Let's prepare to begin today, please. Before we begin, I'd like to make sure that we have a court reporter on the platform. If you are the court reporter on the platform, please unmute yourself or reach out to Sheila, who is our technical host. Sheila, you getting any hits?
No, I'm not.
Hmm.
There's a few phone numbers on the line that I don't know who they are, and there's somebody on the line named Media Monitor that I have unmuted, so I don't know if that should be the court reporter.
So MM on the platform, Media Monitor. If you would please, Sheila's going to invite you to unmute yourself. We would just like to confirm whether you're the court reporter or not. You might have to press Control-Shift-M to unmute yourself. Mm. Are they able to reach out through chat, Sheila?
No, the chat is disabled,
Okay.
but they. Oh,
So I see that someone named Lynette Shear has raised her hand.
yeah, and she signed up for public comment.
All right, how about this? Oh, there, Cynthia Smith, reporter.
Okay, very good.
Terrific. All right, we'll begin then. Thank you, Ms. Smith, for indicating that you're on the platform. So we begin, this is our 9 o'clock public comment session on October 23rd. I don't have anyone on this list of folks who reserved for this particular session, but I do see some hands raised on the platform. Just a few things. I'll ask you to state and spell your first and last name for the transcript. I will ask you if you swear or affirm to tell the truth because the commission rules require that. And I'll ask you to keep your comments to 3 minutes. If you have more to say than that, please submit written comment sometime this week or next, and it will be made part of the record. So, who are we beginning with? Tara Lee Huff Workman. Ms. Workman, can you unmute yourself, please?
Can you hear me?
Yes, thank you very much. Would you spell your first and last name, please?
My first name is capital T-E-R-I, capital L-E-E, no space, no dash, it's all one name. And Huff is capital H-U-F-F, as in Frank. And then Workman is capital W-O-R-K-M-A-N.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
My name is Terry Lee Huff Workman. I bought a home with my husband here in Sandia Heights a little over 4 years ago while I was working on Big Sky I am from Oregon, and I am a location manager in film and TV, third generation in the film business on my mother's side. I take pride in being a liberal Democrat and environmentalist, and for the good of all people, which this bill would not be for. All the people of New Mexico would be seriously suffering, and the state would financially take a nosedive. My degree in public relations, the second in psychology, clearly tells me mental health for citizens would be in jeopardy. I am closely connected to BP America, and people do not realize all the areas that gas and oil play into every day products. My ex-husband was with BP for over 30 years as a supervisor in the electrical department. The oil companies are the foundation, for an enormous amount of the budget of New Mexico, including film incentives, schools, roads, not to mention the huge number of people that would be unemployed instead of, I left that one out. They do not walk away and leave oil wells unsafe. They're not prone to lawsuits. The impact these regulations will have on the state overall would be devastating for the entire state. Again, schools, jobs lost, forcing people to move out of the state for filming and other jobs. This will hurt small business and so much more. I urge you to support New Mexico and not allow this to happen. Thank you for your time.
Thank you, Ms. Workman. Let's see, next we have Paul Gessing, Mr. Gessing. Mr. Gessing, are you able to
I
unmute?
apologize. Can you hear me?
Yes, now I can. Thank you very much. If you
Fantastic.
would please spell your first and last name.
My first name is Paul. My last name is Gessing, Gessing.
Thank you. And do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
My name is Paul Gessing. I'm president of the Rio Grande Foundation. We're a nonpartisan public policy research organization based in Albuquerque that focuses on economic policies that impact our state. I've held that position for nearly 20 years, which is the entire time I've lived in New Mexico. Among the things I enjoy are hiking in the mountains and volcanoes near my home in Albuquerque. I also enjoy playing golf. I have a family with 3 children that I hope someday will be able to find good paying jobs in the land of enchantment. New Mexico is in a strong budget position today, thanks to its leadership as the second largest producer of oil in the entire country. 51% of our budget comes directly from the oil and gas industry. Not only is this money used to fund our schools and roads, but thousands of New Mexicans work in the industry and support their families and pay additional taxes. The growth of this industry right here in New Mexico has helped to make our nation self-sufficient with regard to energy resources. That said, we understand and appreciate the need to balance economic goals with environmental ones. I do urge you to oppose the proposed rules. Anyone who comes to New Mexico can immediately appreciate its beauty. Our blue skies and wide open spaces are part of our heritage and what makes our state the land of enchantment. That said, we are also a poor state that must continue to grow economically. We're simply not in a position to regulate New Mexico's most important industry in ways that will lead to lost revenue for our citizens. I'd like to thank you and the Commission for working to balance the economic needs of New Mexicans and the needs of the oil and gas industry with those for a clean environment where industry restores impacted areas to as close to their natural state as possible. Again, these regulations represent an unnecessary added burden on top of numerous other regulations on New Mexico's most important industry. I urge you to reject them. Thank you.
Thank you, Mr. Gessing. Let's see, we'll hear next from Jocelyn Compton.
Good morning.
Good
My
morning.
name is Jocelyn, Jocelyn, Compton, Compton.
Thank you. Do you swear or affirm to tell the truth?
Yes.
Thank you. I'll start your time.
Good morning. My name is Jocelyn Compton. I'm a reservoir engineer with a small independent oil and gas operator. I've worked in the oil and gas industry for 25 years and for this company for the past 8 years. In that time, I've seen firsthand how we operate with integrity, safely plugging and abandoning wells in Louisiana, Mississippi, and here in New Mexico. But I've also seen something just as important, how responsible small operators can breathe new life into wells that others have given up on. And that's why I'm here today to speak against the proposed rules to raise financial assurance bonding and grant new authority to the New Mexico Oil Conservation Commission to halt private acquisitions. I'd like to share an example of the work my company has done in New Mexico to illustrate why the proposed change would be detrimental to small operators and to the state's energy industry. The company I work for held a small working interest in the South Avalon AUA well near Carlsbad. The well was drilled in 2000, and by June 2007, it met the proposed definition of a marginal well. It remained in that marginal well status for 11 years until the large operator of that well proposed to plug and abandon it. But the company I worked for believed in the well's potential, so we negotiated to take over operations. In 2020, we invested $115,000 to recomplete the well, and since then, it has delivered consistent non-marginal production. That's just one example of how small operators can revitalize wells that larger operators might abandon. If the proposed $150,000 per well bonding requirement had been in place, it would have been impossible for my company to take on this project. A bond of that magnitude would have locked us out of opportunities to revitalize wells. We're also deeply concerned about the additional authority that this proposal grants to the New Mexico Conservation Commission to block private acquisitions. If these new powers had been in place, it might have been possible that we never would have had the chance to take over operatorship of this well and others. Allowing the OCC to unilaterally block acquisitions would stifle opportunities for companies like ours to do the challenging work of revitalizing marginal wells. In short, this proposal creates an environment that is hostile to small operators and would prevent companies like mine from doing the work of maintaining and improving wells. Imposing excessive bonding requirements and granting unchecked authority to block acquisitions only serves to hurt small operators. We need regulations that target bad actors, not a one-size-fits-all policy that punishes good ones. Thank you for your time.
Thank you very much, Ms. Compton. We'll go now to Lynette Shire.
Yes, Shire. You said it right.
Oh, hooray. Would you spell your first and last name, please?
Yes, Lynettete. Last name Shire, Shier.
Do you swear or affirm to tell the truth?
I do.
Thank you. I'll start your time.
Well, good morning. My name is Lynette Shire. I'm 57 years old, disabled, and I've lived in New Mexico since 2009. When I first arrived here, I lived in a travel trailer for a year before settling into my rural home in Laguna in 2010, where due to my progression of my disabilities, I had to stop working and began relying on a caregiver to help me with my daily needs. That caregiver is paid for through Medicaid, which has been a lifeline for me, allowing me to live independently and with dignity. The oil and gas industry plays a vital role in supporting the infrastructure that helps fund personalized medical equipment and essential services like home care. Without it, access to care becomes harder, costs go up, resources dry out, and people like me are left behind. As a disabled person living in New Mexico, I know firsthand how critical affordable energy is. Many of us rely on medical equipment, temperature controlled environments, and reliable transportation, all of which depend on accessible, affordable energy. New Mexico's oil and gas revenue significantly contributes to funding Medicaid, which covers medical services for disabled people like me, through things like the General Fund, which receives about 1/3 of its recurring revenue from the oil and gas industry. We, the disabled citizens of New Mexico, need the oil and gas industry. When energy costs rise, it is not just inconvenient, it's life altering for people like us. Continued drilling and natural gas production with fewer regulations help ensure that disabled people like me can live with dignity, independence, and stability. We all want a safe, healthy, and sustainable future for New Mexico and the United States of America. But I ask that you also consider how these changes could unintentionally harm the very people that you're trying to protect. Regular people, some of us disabled and relying on the medical resources that the oil and gas industry provides, essentially to fund, which is significantly impacted when regulations cause financial stresses. Many smaller oil and gas producers who operate responsibly and contribute meaningfully to our communities may struggle to survive under new regulatory burdens as well. When they're forced to shut down or scale back, the ripple effects reach far beyond the industry. They reach regular people like me. I'm speaking today not just for myself, but for those who cannot be here and often feel unheard. I urge that you think about us, those whose lives are directly affected, when you consider your decisions. Please remember that behind every policy or regulation, there are real people trying to live with dignity and stability. We share your values, and we want what's best for our state and our country. I just ask that you keep us in mind as you move forward. And I thank you so much for your time and for listening to me.
Thank you very much, Ms. Shire. Is there anyone else on the platform who would like to offer comment during this session? We do have another session at 4 p.m. and 2 sessions every day that we continue through hearings. You may raise your virtual hand. If you have dialed in using your phone, you can press *5 to raise your hand. All right. Is there anyone in the room with us this morning who would like to offer public comment? Ma'am, would you come up and join us up here? If you would state and spell your first and last name. Well, we need the microphone.
My name is Connie Huffmeyer.
All right. How do you spell that?
CONNIEHUFFMIRE.
Thank you. And do you swear or affirm to tell the truth?
Yes.
Go ahead. I'll start your time.
Good morning, Chair and Commissioners. I'm in strong support of the proposed bonding rule changes that will motivate the oil and gas companies to pay the full cost of cleaning up after drilling on New Mexico state trust lands. There are hundreds of abandoned wells currently not plugged. Thousands more are expected to be abandoned. The state of New Mexico has already spent over $100 million to plug these wells, but the New Mexico government funds could be used for other important costs to support its citizens. If the bonding rules are not modernized, then New Mexico and taxpayers face being left on the hook for over $1 billion to plug the abandoned wells and future cleanup costs. We need to change the bonding and cleanup rules so the companies who drill for oil and gas are held accountable for their cleanup of the wells and preventing the abandonment of more well sites. It's common sense that if a well is drilled with chemicals left on site that harm the groundwater and the air, that the company should take the time and pay the cost to seal off those chemicals from spreading into water and air. The health and safety of rural communities are harmed by the chemicals. In the rural areas of New Mexico, abandoned wells currently number in the hundreds, and there will potentially be thousands more. The oil and gas business would like everyone to ignore this issue so they can walk away and not be responsible for the future pollution. After all, we don't see the methane, yet we know it's harmful to the air. We need to put our New Mexico citizens first by reducing chemical pollution to our water, land, and air. After modernizing the bonding rules, the state can make the oil and gas companies responsible for cleaning up the damage they have created. When a business does abandon a well, the state of New Mexico will have a high enough bond payment to plug the well soon after the business leaves the site. It is best to prevent a crisis now instead of trying to fix this problem later. Thank you.
Thank you very much, Ms. Huffmeyer. I don't see anyone else in the room who might be here to offer public comment. So we'll return to the technical case. Let's see, we need Mr. Morgan back in the hot seat there. And we'll begin this morning with cross-examination unless there is a preliminary matter someone would like to raise. No. Okay, terrific. Mr. Cloutier, are you starting it off?
Good morning, Madam Hearing Officer. Ann Tripp, who's appearing remotely, will be handling the cross-examination.
Thank you very much. Ms. Tripp?
Thank you, Madam Hearing Officer. Good morning, and good morning, Commissioners. Mr. Morgan, my name's Ann Tripp, and I'm an attorney for the Independent Petroleum Association of New Mexico. Thank you for returning. I know we are on day 3, and I hope I can make this quick. Also, since I'm appearing remotely, if there's any problem with audio or if I'm speaking too fast or if I'm not allowing enough time, you please let me know.
Will do. Thank you.
Thank you. So I just like to start a bit to cover some of your experience. And it's my understanding that you're currently with the Center for Asset Retirement Accountability, or CARA. Is that correct?
That's correct.
Okay. And is that a 501c3 nonprofit? How is that group organized?
It is, yes. We are a 501c3. We are a project of the Resources Legacy Fund, which holds the 501c3 status.
And what is the Resources Legacy Fund?
It's a organization that hosts and supports a number of organizations focused on a variety of environmental issues.
Okay. And in your direct testimony, you mentioned that you testified before the U.S. House of Representatives on some matters. I believe it was fossil fuel extraction sites. Is that correct?
That's correct.
But the fossil fuel extraction sites were specific to coal mines. That was not specific to oil and gas wells. Is that right?
The hearing was focused on coal mines. My testimony addressed issues related to reclamation, surety bonding, decommissioning, transfer of permits, essentially very similar issues to what I'm testifying to in this matter.
That's fair, but all of those issues were related to abandonment or reclamation of coal mines, not to oil and gas wells in the state of New Mexico. Is that fair?
That's correct.
Thank you. And so it's my understanding that you're also an attorney. Is that correct?
That's correct.
And so you know, we've spent a little time in the past 2 days asking the wrong witnesses, the wrong questions in terms of who's an expert on what. And so it's my understanding that you're appearing today to offer your opinion as both a legal expert and based on your experience.
That's correct.
Okay. And so your direct testimony is Exhibit 15, and your rebuttal testimony is marked as Exhibit 81. And yesterday you also offered rebuttal testimony, correct?
That's correct.
And so to the extent that your testimony, either in direct or rebuttal or rebuttal, is factual, that's based on your personal knowledge.
My personal knowledge and my review of the various studies and literature cited in my testimony.
Thank you. And then to the extent that your testimony offers an opinion, that opinion is based on the application of your experience and expertise to those facts or to the review of those facts. Is that fair?
That's correct.
Thank you. And so as an attorney, what states are you licensed or admitted in?
I have an active admission in Colorado and an inactive admission in California.
Have you ever practiced in New Mexico?
I have not, no.
And so we heard earlier that this process in terms of the application of the proposed rules, that started in summer 2023. Can you speak a bit to that?
I believe that was before my involvement in the matter.
When did you get involved in the drafting or the proposal of rules?
I believe that was in the late summer or fall of 2024.
Okay, thank you. Have you previously appeared in New Mexico legislative or rulemaking activities?
I have not, no.
Okay. And so yesterday you testified a bit about the authority of the Oil Conservation Commission to adopt these proposed rules. Is that accurate?
As relates to certain of the proposals, yes.
Okay. Well, specifically with respect to the ability of the Oil Conservation Commission to adopt single well bonding requirements for additional categories of wells.
Yes, that's correct.
Okay. And so I'd like to walk this back a little bit because I think there may be some confusion about how those bonds and current rules and the effect of the proposed rules would have on the entire inventory of wells in New Mexico. So would you agree that there are two primary categories of wells, active wells and inactive wells?
I'm sorry, do you mean under the current regulations or under the proposed amendments?
Under the current regulations.
Yes, that's correct.
Okay. And within active wells, that means any well that is producing, regardless of production levels or thresholds or days of production.
That's right.
Okay, and so then within the category of inactive wells, there are temporary abandoned wells, approved temporary abandoned wells, expired temporary abandoned wells, and orphaned wells.
I believe that's correct.
Are there any other wells that you would throw under that? I know that there are several groups there that I listed. Are there any other scenarios or situations that you would consider a well inactive?
I'm sorry, could you repeat the list of categories once again? And I would like to clarify my previous answer. As I understand it, under the current inactive well category, it only applies to wells that have been in temporary abandoned status for more than 2 years.
Thank you. So the wells that I listed under the group in the bucket of inactive are temporary abandoned, approved temporary abandoned, expired temporary abandoned wells, and orphaned wells.
That's right. Although again, in the current regulation, it distinguishes wells that have been in temporary abandoned status for more than 2 years. But the proposal would effectively eliminate that distinction.
Okay. And so within the group of active wells, the proposed definition of marginal or low producing, I'm going to use as a proxy for presumption against beneficial use. So for marginal or low producing wells, those are active wells. Is that correct?
I'm sorry, could you clarify the distinction you just made?
Okay, so I'm going to use the term low producing, I'm putting it in air quotes here, to mean the presumption against beneficial use, the less than 90 BOE and less than 90 days. So that's kind of my preliminary. And so the question I have for you is that marginal wells and low producing wells are active wells.
Okay, I do want to clarify that the term low producing wells doesn't appear in either the current regulations or the proposed amendments.
Yes, I agree, but I can, okay, so there are two categories of wells. Marginal wells, meaning well in the proposed rules, that's less than 180 days of production, less than 1,000 BOE per year. There's a second category of wells that applicants are proposing additional financial assurance for, and that is for a presumption against beneficial use, correct? Which would fall in the inactive category. And the presumption against beneficial use comes into play when wells are less than 90 BOE per year and less than 90 days of production.
Yes, I understand. Thank you.
Okay, so for marginal and wells that are presumed against beneficial use, both of those wells are considered active under the current regulations.
That's my understanding, yes.
And what is your understanding based on?
Based on the statutory and language of the current regulations and the limited categories that are currently provided.
So in the preparation of your testimony and your opinion, you reviewed the statutes within the Oil and Gas Act and the corresponding regulations within the New Mexico Administrative Code.
That's correct.
And that required an interpretation of Section 70-2-14, which is requirement for financial assurance under the Oil and Gas Act.
That's correct.
So you are familiar with that statute?
I am, yes.
And I understand it's your testimony that under that statute, the Oil Conservation Commission has the ability to adopt new categories of single well financial assurance.
That's correct.
And so in forming that opinion, did you go beyond the plain language of the statute?
I did not know.
So you didn't review any of the historical versions of the statute or the historical regulations for the Oil Conservation Commission?
I'm aware of some of the history of amendments, but my focus was on the current language of the statute and the regulations.
Okay, and so to the extent that you're aware of amendments to the statute, what changes were those?
I believe that in the most recent changes to the statute, there were adjustments to the amounts for the cap of the blanket financial assurance and the establishment of the floor of $50,000 for the blanket financial assurance for temporarily abandoned status wells.
So under the current statutory and regulatory scheme for financial assurance, what are the bonds that are required of operators in New Mexico?
I'm sorry, could you repeat the question?
Yes. So under the existing statute and regulations, what are the types of bonds that are required of operators in New Mexico?
So under the regulation, there is for active wells, this is 1915-89C. There's a one well financial assurance in the amount of $25,000 plus $2 per foot of the projected depth of the well. And there are blanket plugging financial assurances with various categories ranging from $50,000 for 1 to 10 wells to $250,000 for more than 100 wells. And for inactive wells, it provides that an operator shall provide financial assurance for wells covered by subsection A of 1915-8-9 that have been in temporarily abandoned status for more than 2 years, or for which the operator is seeking approved temporary abandonment, with a one well financial assurance of $25,000 per $2 plus $2 per foot of the depth of the well, and a blanket plugging financial assurance with various categories ranging from $150,000 for 1 to 5 wells to $1 million for more than 25 wells.
And so is there any distinction between a single well bond for an active well and a single well bond for a temporary abandoned well greater than 2 years?
Not as I read the current regulation, no.
So would it be a fair summary that there are 3 types of bonds in New Mexico? There is a blanket bond for active wells, there's a blanket bond for temporary abandoned status wells, and then there is a single well bond.
I believe that's accurate, yes.
Okay. And then the greatest amount of bonding that could be required of an operator, if you assume $250,000 for an active well bond and the $1 million blanket bond covering TA wells, would be $1,250,000.
That would, I'm sorry. I don't think I followed that. I was with you right up until the end.
Sure. So to the extent active wells are covered by a blanket plugging bond of $250,000 at the highest tier, and then to the extent that there are blanket TA bonds available up to $1 million, currently under the regulations and under the statute, a $1,250,000 financial assurance requirement would be at the peak under New Mexico law.
I don't believe that's correct. Theoretically, an operator could opt for the individual well bonding, and depending on the number of wells they had, that could reach an amount higher than $1,250,000.
That's fair. So to the extent that an operator elected not to single well bond additional wells, you would agree that $250,000 and $1 million are the caps for the blanket bonds available.
That's correct, yes.
Okay. Have you performed any analysis of what operators would see their financial assurance changed under the proposed rules?
I have not. That would depend on a variety of different factors for different operators. So I have not looked at a hypothetical or actual case for that, no.
Okay, but under the proposal that $150,000 for a single well bond would be required of marginal or inactive wells, that $150,000 gets you to $1 million at 6.7 wells.
That sounds correct.
Okay. And then to the extent that you had 67 wells, that would be a $10 million financial assurance requirement.
That would be the financial assurance requirement, yes.
Okay. And so I'm going to, so you mentioned that you hadn't reviewed the history of the statute for 70-2-14 or its predecessors. You've not really looked at the historical regulations, so we won't go into those. But are you aware of the primary duty of the Oil Conservation Commission?
I have reviewed that statutory language, yes.
And so what are those duties of the Conservation Commission?
As I read the statute, the duties of the Conservation Commission are to give effect to all provisions of the Oil and Gas Act.
Have you reviewed section 70-2-6 or 70-2-2, any of it where waste is prohibited, and that the primary duties of the Oil Conservation Commission are to prevent waste and to protect correlative rights? Are you familiar with those phrases?
I have read those. I've also read 70-2-11, which also defines the responsibilities of the commission. And I understand that prevention of waste is among the duties of the commission, but I don't believe it is the sole duty of the commission.
Would you agree that prevention of waste is the paramount duty of the Oil Conservation Commission?
No.
And you've also not reviewed any case law interpreting those statutes. Is that fair?
I have looked for case law interpreting those provisions of the statute, but I did not find anything that spoke directly to that issue.
And I'm sorry, I just want to be clear that you've looked at case law in New Mexico, controlling from the New Mexico Supreme Court or New Mexico Court of Appeals on what the primary or paramount duty of the Oil Conservation Commission, and it's your testimony that you could not find anything addressing that?
I didn't find anything that spoke beyond the terms of the statute, no.
And so would you disagree that prevention of waste is the paramount duty of the commission?
That's not my reading of the statute, no.
And there's no opinion of the New Mexico Supreme Court directing the commission to follow that?
Not that I saw, no.
But you're here today on behalf of applicants as the legal expert to tell the commission that they have authority to adopt these proposed financial assurance rules.
That is the subject of my testimony, yes, but I also understand these issues will be addressed by the attorneys representing the applicants in any post-hearing briefing.
And so to the extent of your testimony covers the plain language of the statute and doesn't go beyond that. Is that a fair summary?
I believe that's correct, yes.
Okay. And I think we talked about it earlier that, well, maybe we haven't. You said you were aware of prior amendments. Did you review any of the deliberations or transcripts from the prior amendments in which this commission changed or adopted new rules?
I did not know.
Okay. But you're aware that Senate Bill 189 adjusted the financial assurance cap for active wells from 50,000 to 250,000.
I am, yes.
Okay. And you've not reviewed the order that resulted from that rulemaking proceeding?
I have not, no.
And I'm just going to share my screen here. I can get to the right thing. I'm sorry, it doesn't show me what is this large enough to read? Maybe I make it bigger. It should be, it's labeled as Exhibit C. This is Exhibit C to IPNM and NMOGA's joint reply. This is Order R14384 in case number 16078. Can you see my screen as well?
I can, yes.
Okay, all right. So this is the order from the commission that resulted from that prior rulemaking, which followed the legislative direction to increase financial assurance for active wells from 50,000 to 250,000. And I just want to look at this first paragraph, which describes statutory authority, and that's the act referring to the Oil and Gas Act specifies the requirements for types and amounts of acceptable financial assurance and requires the adoption of rules to establish amounts. Would you agree that's a fair summary of Section 70-2-14 of the Oil and Gas Act?
Yes.
Okay. I'm sorry, I'm scrolling a little fast, but I don't want to make anyone dizzy. So this is page 3, paragraph 9 of that order. And this is Allison Marks, who was a witness for the Oil Conservation Division during the rulemaking hearing. And I have highlighted the third sentence in that the act was amended in 2018 to increase the cap on blanket financial assurance for active wells from 50,000 to 250,000. Did I read that correctly?
Yes.
Okay. And there's just one final point that I want to look at in this decision from the Oil Conservation Commission, and that's regarding to the reasoning for adopting the rule changes. This is paragraph 19, that the commission, and I'm sorry, let me get to the 2, 3. I think it's the 5th sentence that I have highlighted, but the commission finds that the proposed rule change as modified increases the financial assurance as required by the act without unnecessarily burdening small operators. In paragraph 20, the commission goes on to find in its reasoning for adopting the rule change, by not unreasonably burdening small operators who could be forced to plug low volume wells, the proposal avoids potential waste. And then the commission cites to 70-2-3, 70-2-6, and 70-2-11. But you've not reviewed any of this and offering your legal opinion today on adoption of the rules.
I have not, no.
All right, but I do believe you've reviewed the Legislative Finance Committee report. That's Welk's Exhibit 4. Are you familiar with that?
I am, yes.
Okay. And this report, timing wise, it was presented at a Legislative Finance Committee hearing on June 24th, 2025. So to the extent that the proposed rules were drafted and submitted in June of 2024, what information were you relying on at that time for the authority of the commission?
Again, for the authority of the commission, that would have been the New Mexico statutes.
Okay, but now that we do have this report, which is cited repeatedly throughout testimony for applicants, I don't think we have to go beyond the recommendations from the Legislative Finance Committee. Did you review those?
I reviewed the entire report, yes.
Okay, so let me share my screen. This is Exhibit 4, page 2. And I've tried to highlight throughout in green to distinguish between any yellow highlighting and Welk's Exhibit 7.2, which shows changes to the proposed rules. And then there's orange highlighting that was submitted in this exhibit. And so this is page 2, key recommendations. The second bullet that's highlighted in orange, and I put a blue box around it, is that the legislature should consider amending section 70-2-14 to specify that wells producing below certain thresholds set in rule require additional financial assurance. Did I read that second bullet correctly?
Yes.
All right. So how does that square with your opinion that the commission can adopt rules increasing additional financial assurance for low producing wells or marginal wells?
These are not exclusive categories. Just because the Legislative Finance Committee recommended changing the statute doesn't mean that the commission doesn't also have authority to independently adopt rule changes that would have the same effect. Nothing in the Legislative Finance Committee says that the only a statutory change could bring about those additions or amendments to the financial assurance requirements in the regulation.
Have you reviewed any, so you're aware of the prior amendments. Are you aware of the commission adopting or changing financial assurance without being prompted by the legislature in the past?
Not specifically, no.
And there's two other areas within the Legislative Finance Committee report that that I wanted to explore. And the first one is the cost, the $150,000 that applicants have proposed for financial assurance. And I'm paraphrasing, but stating that $150,000 is the average cost to plug a well. Where did applicants develop that $150,000?
So I think one important thing to point out, one development that's occurred between 2018 and now is a much greater understanding of the orphan well crisis, both in New Mexico and nationwide, and the $4.7 billion in funding that was provided under the federal infrastructure bill, which has led to rapid changes and development in the understanding of the number of orphan wells and the cost of plugging those wells. As that $4.7 billion in funding has been distributed to states, including New Mexico, the number of orphan wells plugged has increased dramatically, and therefore the information available on what goes into plugging those wells and the cost of plugging those wells has increased really dramatically, including in New Mexico. And what this has led across the board is, in many cases, an order of magnitude increase in the understanding of the cost of plugging orphan wells. So it was really that information specific to New Mexico and OCD's implementation of orphan well plugging that both prompted the application for rulemaking and that generated the information that informed the $150,000 figure. So the sources that we relied on in getting that figure include OCD's applications to the Department of Interior for that orphan well plugging funding. And that includes in 2021, in the initial notice of intent to apply, OCD reported that it was estimating spending $290,611,502 to plug and remediate 1,741 orphan wells in New Mexico, which works out to a per well cost of $166,922.17 per well. Then in 2024, in OCD's Phase 2 work plan proposal to the Department of Interior for additional orphan well plugging funds, based on OCD's 3 years of experience implementing that orphan well plugging program, OCD indicated an average plugging cost of $180,000. Similarly, and growing from that same pool of data of OCD invoices, in the 2025 legislative session, the Legislative Finance Committee submitted a fiscal impact report for House Bill 481, where the LFC reported OCD's average well plugging cost at $163,000. And then again, as you've already cited, in the most recent Legislative Finance Committee report on orphan wells, the Legislative Finance Committee again reported that OCD average plugging cost of $163,000 per well.
Okay, all right. Thank you for that summary. So it's my understanding that 163,000 is pulled purely from OCD numbers. Is that fair?
Yes, and that's because that's really the only relevant consideration, because when a well is orphaned into Mexico, OCD is responsible for plugging that well. So the relevant figure for the cost to OCD of plugging that well is OCD's average cost in plugging orphan wells.
And I'm also glad that you highlighted the Infrastructure Act, which provided these federal funding, because it's my understanding that the tranches of the funding provided the state are based on various metrics, which include orphan well counts, and it also includes adoption or changes to regulations. Is that fair?
The portion of the infrastructure bill that provides a round of grant funding based on the state regulatory program is, I believe, still under review by the Department of Interior. And I don't know what the final outcome of that process will be and what metrics they will use to evaluate the state regulatory programs. That was intended in the statutory language, but it's unclear how it will be implemented by the agency.
But I understand that the availability of these funds have made a concrete change in the way the division is approaching orphan wells and also the data that they're gathering. Is that correct?
It's led to a rapid and significant expansion of the number of orphan wells plugged, and therefore understanding of what goes into plugging orphan wells.
And when you say that this number, like OCD, that OCD's cost is the only relevant figure in this, excuse me, in this rulemaking, I'm going to go back to, this is from your demonstrative PowerPoint slides. It's page 4, and share. And so this is section 70-2-14, and I've added some highlighting inspired by Mr. Rankin in a rainbow of colors to highlight the different provisions here. And so in the language of the statute, which directs how the commission is supposed to adopt rules for financial assurance, in establishing the categories of financial assurance, the oil conservation shall consider depth of the well involved, the length of time since the well was produced, the cost of plugging similar wells, and such other factors as the Oil Conservation Division deems relevant. That is, there's four parameters there, or four instructions on establishing categories. Did I read that correctly?
Yes, although I would dispute that characterization slightly in that the fourth factor is a catch-all, and so theoretically can incorporate multiple additional factors.
Yes, much similar to Mr. Alexander's testimony earlier about such as, that's an expansive category. But the sentence in it just prior to that is that the one well plugging financial assurance and amounts determined sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance. And so that's the direction on how the commission is supposed to set the one well plugging amounts or the single well bonds. Is that correct?
The sentence you just quoted that's highlighted in blue, yes, is speaking to the one well plugging financial assurance.
And it would be your position then that reasonably pay the cost of plugging the wells, we should insert language that it's the cost of the division to reasonably pay the cost of the plugging the wells. We should insert that language into the statute.
I don't think it's necessary to insert any language because the final phrase of that sentence covered by the financial assurance, I believe captures that because the purpose of the financial assurance or one of the purposes of the financial assurance is to provide OCD with the funds necessary to plug the wells. And so, again, in every case when an orphan well is plugged in New Mexico, it's plugged by OCD. And so that measure of whether the financial assurance covers that cost necessarily derives from OCD's actual costs.
But we heard testimony earlier that industry is plugging 95% of the wells. And so to the extent that...
I'm sorry, did you say that was my testimony?
I'm not sure if it was, would you dispute that industry plugs 95% of wells in New Mexico?
I dispute that characterization. 95% of the wells that have been plugged in New Mexico have been plugged by industry. That doesn't mean that industry plugs 95% of the wells in New Mexico. There's currently 63,000 unplugged wells in New Mexico. Over the last 20 years, only 20,000 wells have been plugged. I think of this as, I have kids at home and the floor of our family room is covered in Legos, right? So if I pick up a couple of Legos and my kids pick up a couple handfuls of Legos, then 95% of the Legos that have been picked up in my house were picked up by my kids. But the floor of my family room is still covered in Legos.
That's a fair analogy for that scenario. However, when we talk about 63,000 unplugged wells, we're not talking about 63,000 inactive orphaned wells. Fair, is that correct?
No, that's correct. But I dispute the characterization that 95% of wells in New Mexico have been plugged by industry because 95% of wells in New Mexico have not been plugged.
Thank you for clarifying on the percentage. But to the extent that your position is that the only cost that matters is the cost to division, we're talking about 5% of wells which get plugged. And so the 5% should be the relevant factor for the commission to consider.
Yes, because again, OCD is the one who plugs orphan wells. And so the financial assurance has to be sufficient to cover OCD's costs in plugging orphan wells.
And then on the contribution of financial assurance to plugging costs, you've cited to the reclamation reports, I believe from 2019 to present, at least 2024. And so does financial assurance provide any significant portion of the funds for which the OCD uses to plug wells in New Mexico?
Not currently, no.
In fact, in 2021, only $167,000 was recovered in financial assurance, and in 2024, 180. Oh, I'm sorry, I'm using the wrong numbers. Those are the average plugging costs. I believe it's to the tune of somewhere into 225 to 250,000. I can pull up those reclamation reports if you'd like to review them.
Yes, I don't have them in front of me, but that final figure you gave sounds about correct.
Okay, and the size of the reclamation fund currently, which is primarily funded from the oil and gas conservation tax, that's 67 million.
Right, or enough to cover the plugging of approximately 400 wells at OCD's average cost.
But OCD's average cost is not the average cost that the industry would experience. Is that correct?
No, when industry plugs its own wells, the cost will vary, but may not be the same average as OCD encounters.
And one of those recommendations and one of the areas examined in Exhibit 4, the Legislative Finance Committee report, is about the difficulty of OCD to control its costs in plugging wells. Did you review those portions?
I did, yes.
So to the extent that statewide price agreements, that limited plugging contractors located in the northwest corner, plugging wells in the southeast corner, and per diem rates and standby rates, to the extent those all increase costs, those costs are incorporated in that $163,000 number. Is that correct?
That's correct. And that's part of the reason why the figure we used in our proposal is below the $163,000 at $150,000.
And it's also that I believe you offered some testimony in Sir rebuttal and in your possibly in your direct and rebuttal testimony, but it's regarding the way financial assurance works, and that the state of New Mexico could simply release an operator from a surety bond if their wells exceeded the marginal levels. Do you recall that?
Yes, that's my understanding.
And so in coming to that opinion, have you reviewed any surety agreements?
I have reviewed surety agreements in the past and am generally familiar with terms that appear in such agreements.
Specific to this rulemaking and this proposal, have you reviewed any of the surety agreements which involve operators in New Mexico and the state of New Mexico as the beneficiary?
I don't believe so, no.
Okay, and so you haven't reviewed the form that OCD promulgates for surety bonds?
Not the current form, no form on that, no. I guess the point I was trying to make is that OCD would be free to amend that form to reflect the language in the regulation once finalized.
No, I think I'm going to differ in the interpretation of the statute there. So you just said OCD could modify its form to provide for release. But we were just looking at section 70-2-14, which establishes the requirement for financial assurance. And that very last sentence that I have highlighted in purple is that all financial assurance shall remain in force until released by the Oil Conservation Division. And then if you go look to the regulation, it requires a well to be plugged prior to release of financial assurance.
I don't have that in front of me.
Sure, let me find it for you just a second.
Ms. Tripp, you have about 5 minutes.
Thank you, Madam Hearing Officer. So this is the current form of NMAC 19-15-8. And at 1915-8-12, release of financial assurance. Are you seeing the same thing I am at this point, Mr. Morgan?
I am, yes, thank you.
Okay, all right. The division shall release a financial assurance document upon the operator's or surety's written request if all wells drilled or acquired under that financial assurance have been plugged and abandoned. Did I read that correctly?
Yes, although you have only read a fragment, and the end of that sentence is, or have been covered by another financial assurance the division has approved, which in the case of changing a well from marginal well status, if the operator provided a subsequent surety bond that covered the adjusted amount without the marginal well coverage, OCD could accept that surety bond and release the prior bond.
And so it's your opinion that the division could adopt, and is that opinion based on any discussions with surety companies in terms of if they would agree to that?
I'm sorry, you didn't complete the original phrase that you asked me to agree to.
Thank you. But in terms of releasing a marginal wells bond that's posted, that's based on your interpretation of what the division's discretion is.
Again, I just cited the language in the regulation which allows the acceptance of an alternate financial assurance that the division has approved as a grounds for releasing a current surety bond. So again, theoretically, under the regulation, that mechanism is available in the case where one or more wells come out of the marginal well status and a lower financial assurance amount is available going forward.
And another two studies that you cited to and referenced yesterday in testimony, the Boomhauer of 2000 and the Lang studies, which both refer to Texas and North Dakota. Are you familiar with those?
I am, yes.
Okay, and you said in absolute terms the levels are different, and in fact the levels are very different. In Texas, the change was from $0 to $250,000, and there was no marginal or low producing well provision. Is that accurate?
That's my understanding, yes.
And in North Dakota, the change in bonding levels was from 10,000 to 20,000. Is that also accurate?
That's correct. And as I indicated in my testimony, I think the focus there is the magnitude of the change in each state from the prior program, which is particularly notable in Texas, where, as you just noted, they were starting at zero financial assurance required.
But none of the studies or the metrics from Boomhauer or Lang have been taken and applied to New Mexico. There's not been an analysis or a model run, or you have not done that.
No, I have not.
Okay. And I know I'm very short on time, so I want to discuss the well transfer restrictions that are in the proposed rules, specifically with the 25%. And I have it before you on your screen. This is from your demonstrative. It's page 14. And I'm really only concerned with this green highlighted language because it states the certification that's required is that the new operator, if officer, director, or partner who is or was within the past 5 years an officer, director, or partner, or person with an interest exceeding 25% in another entity that is not currently in compliance with subsection A, that would defeat their ability to transfer the well. Is that your understanding of how the rule works?
No, under that scenario, OCD would have discretion to not approve the change of operator application. But I don't believe it's mandatory.
All right, not mandatory. And so this is just a visual for me because that language, I get lost in it. Is this an accurate representation of what the proposed rule is trying to accomplish? That if an officer, director, partner, or interest owner of operator B who's looking to take over a well from operator A, if any of those parties in the past 5 years of operator X, if operator X is not currently in compliance at the time of the well transfer, which is not when any of those officer, directors, partners, or interest owners are actively in operator X or employed by or have an interest in. But that is the criteria that OCD has discretion over.
I'm sorry, I haven't seen this figure before, and I'm not entirely able to follow the relationship between some of the boxes indicated here.
Okay, all right, well, let's go back to the rule, which is in your demonstrative. Okay, you would agree it's officer, director, or partner in the new operator. So that's operator B. And then who is or was within the past 5 years. So understandably, it involves somebody who currently owns an interest. However, was within the past 5 years means that if that officer, director, or partner was associated with operator X in the past 5 years, and another entity that is not currently in compliance, meaning operator X is not currently in compliance when operator B is seeking to take ownership of a well, that the division may deny registration, may deny the transfer.
Well, the language you just quoted is from what would be the disclosure that would be required from the companies. The language specific to OCD's discretion to deny operator registration didn't appear on the screen you were just showing.
Okay, let me show you
Ms. Tripp,
Yes,
Ms.
ma'am.
Tripp, your time is up.
My time is up. Okay. All right.
Yeah.
Thank you, Mr. Morgan.
Mr. Suazo?
Thank you, Madam Hearing Officer. Good morning, Mr. Morgan. How are you today?
I'm doing all right. How are you?
I'm doing well, thank you. I'm Miguel Suazo. I'm representing the New Mexico Oil and Gas Association, and I just have a few questions for you. I'm going to try not to overlap with the questions that Ms. Tripp asked to the best I can, but there may be some, so forgive me in advance. When Ms. Tripp was asking you questions, you said that you had not reviewed any New Mexico case law covering the authority of the commission, correct?
That is correct, yeah.
Okay. Are you familiar with the New Mexico Compilation Commission?
The Compilation Commission?
Yes.
I'm not, no.
So as I understand what it is, it's essentially a repository for New Mexico law, regulations, case law, things like that. Does that sound reasonable to you? Okay. I'm going to show you, or my associate's going to pull up on the screen, a case from the New Mexico Compilation Commission, which is publicly available. And I am going to ask you to read what he highlighted starting with paragraph 26. Could you please read that?
It says, it is apparent from a study of the entire act, is it all right if I skip the citations there? That the two fundamental powers and duties of the commission are prevention of waste and protection of correlative rights.
And can you tell what year that case was established by the New Mexico Supreme Court?
I cannot know.
Oh,
Excuse me, Mr. Suazo, could you please cite to the case number?
sure.
And Madam Hearing
It is
Officer,
on
thank
the
you.
screen. My eyes may not be able to read it from here.
Do you want me to read it?
Sure.
Continental Oil Company, a variety of other petroleum companies versus the Oil Conservation Commission, May 16, 1962. And the citation is 1962-NMSC-062 70 NM 310, et cetera.
Thank you, Madam Hearing Officer. So would you agree that New Mexico case law has clearly established the two primary duties of the commission?
Primary but not exclusive.
Fair enough. And you've been working on this rulemaking proposal for over a year and a half, is that fair?
That sounds about right.
And in that time, have you had access to New Mexico lawyers to help you find cases like this?
I have, but again, I'm not counsel for the applicants.
But you're testifying as legal and policy director for, I believe, CARA, you said, on behalf of WELC?
That's correct, yes.
Okay. So I guess, you know, could you understand how it might be frustrating for my client and the members that make it up to hear that you're here today in this capacity, making recommendations to this commission on major changes to the Oil and Gas Act and the implementing rules. And in a year and a half, you haven't found, you know, a pretty fundamental case establishing the commission's authority. Could you see how that might be concerning?
Well, again, as I testified, my review was primarily focused on the plain statutory language. which, as I acknowledged in my responses previously, I did review the provisions cited there, but I also reviewed the additional portions of the Oil and Gas Act, and that's what I based my opinions on.
Okay. So you're not a New Mexico lawyer, correct?
That's correct.
You've never helped operators comply with oil conservation division rules.
That's correct.
Okay. Now, CARA was founded, I'm sorry, did I interrupt you? Okay, I thought you said something. CARA was founded in 2024, just prior to this rulemaking, correct?
Yes.
Okay. And CARA is an advocacy organization focused on policy change. Is that right?
That's a fair characterization.
Okay. So would you characterize your role in this proceeding more as a policy advocate?
I would say as a policy expert.
Policy expert, but not on New Mexico policy.
My expertise encompasses oil and gas regulations and orphan well issues nationwide, including in New Mexico.
In a state where you're not licensed.
That's correct.
You're not a financial assurance expert, are you?
I have extensive experience with financial assurances for fossil fuel extractors.
Do you hold yourself out as a financial assurance expert, though?
In certain contexts, I do, yes.
Okay. Which context?
In the setting of appropriate policies for financial assurances to ensure cleanup of fossil fuel extraction projects at no or minimal cost to states and taxpayers.
Now, in your testimony, and I'm specifically talking about your direct, you repeatedly accuse operators of avoiding cleanup and enjoying substantial profits and passing costs to taxpayers. Is that accurate?
Generally speaking, yes.
Okay. Would you agree that that statement alone from your testimony reveals animus towards the oil and gas industry rather than expert neutrality?
I do not. I think I'm calling it as I see it and describing the current state of affairs.
So you don't think that sounds like it's anti the industry?
Again, I'm describing the situation as I see it on the ground. If that description makes the industry come off poorly, that is that speaks to what industry is doing currently rather than a biased opinion on it.
Well, I appreciate you telling us how you see that statement. Thank you. I'd like to ask you a little bit about your direct pre-hearing statement, specifically lines 2 through 5. And I'm just gonna,
on what page?
Page 320. I'll give you time to get to it.
Sorry, the numbering that I have doesn't include.
Oh yeah, you guys have
320.
Bates, and then there's direct pre-hearing statement, lines 2 through 5. It's Bates,
Council, are you able to put it up on the screen so we can all be on the same page?
sure. It's Bates 320.
I'm sorry, again, I don't have a Bates stamped version in front of me.
Okay.
Are you able to give the page number at the bottom of the page?
I can once we get to the Bates.
Oh, I see. You were directing your associate. I apologize.
Page 33 is what I see above 320.
Thank you so much.
Okay, lines 2 through 5. And I'm hoping you can read the sentence starting with the word although.
Although such changes may lead some small operators to exit the market, these operators are the ones most likely to orphan wells and to have other compliance problems. Other operators are able to take over the wells of operators who exit the market or are otherwise make up the production.
Thank you. So I guess just to paraphrase that, you're saying that even though small operators are the intended target here in this rulemaking, after these assets are assumed by larger companies, those larger companies will be willing to take on these liabilities. Is that fair?
As an initial matter, I fundamentally disagree with the premise of your question that small operators are the target of this rulemaking. The rulemaking applies to all operators regardless of size.
Okay, but it does have a greater effect on smaller operators. I think you heard testimony from your other witnesses to that effect yesterday, and I think that this statement more or less reflects that. I mean, correct me if I'm wrong.
It has a greater effect on operators of low producing wells.
Which tend to be smaller?
That's correct.
Okay.
But again, I object to the use of the term targeted.
That's fine. I understand. I appreciate the clarification. Let's talk about some of the information you relied on in your testimony. You rely extensively on Mr. Purvis's data in your direct and rebuttal. Is that right?
I rely on his data. I'm not sure I rely on it extensively.
Okay. Did you rely on his holdback concept?
Not specifically, no.
Okay. I'm going to move on to another topic. You've accused NMOGA and IPNM of having a financial interest in maintaining the status quo, but your organization, CARA, relies on the claim that bonding levels are too low everywhere, nationwide. Is that fair? I'll get to the second part of the question.
Yeah, I object to the characterization both of my accusation of your organization.
Okay, let me kind of rephrase to better frame it for you. So you've accused NMOGA of having a financial interest in keeping the status quo, but
again, nothing in any of my testimony is specific to NMOGA or NMOGA's motivations.
We can look at your rebuttal, Bates stamp 1125 lines 3 through 15, where you describe CARA's mission.
Okay, I'm happy to speak about my organization,
Okay.
but again, you accused me of statements about NMOGA, which I don't believe I've made.
Okay, well, I'm not going to belabor that point because it's the sub point to what I'd like to ask, but CARA essentially relies on the same narrative for its business model, correct?
CARA has no business model.
It doesn't have well, how is it funded?
We're a nonprofit organization.
And what kind of work does it do to maintain that funding?
We provide expertise on issues related to oil and gas decommissioning.
So its business model is to keep the discourse around oil and gas decommissioning so it can continue its funding.
The discourse is present regardless of what actions CARA does or does not take.
But you're funded to maintain that discourse nationwide?
I would not agree with that, no.
Well, what are you funded for?
We are funded to provide expert assessments of the status of well orphaning and to identify policy interventions that could address that trend of well orphaning. But again, that's building off of the situation on the ground, which is approximately 1 million orphan wells in the United States. So we are responding to that tangible situation rather than creating or manufacturing one.
I mean, I don't know any better, but that sounds like a nonprofit business model to me. What you just described, you're funded to execute those purposes.
Okay.
Okay. Let's talk about the New Mexico LFC report. Would you agree that it says that there's roughly 2,100 wells that require plugging or will likely require that in the near term?
Yes.
And you state that these estimated figures are consistent with estimates provided by OCD to the federal government in 2021 when they requested federal funds for orphan wells. Is that right?
That's correct.
Now, it's your testimony that the ranks of orphaned wells grow every year, correct?
I don't think I testified specifically to that statement, but that sounds generally correct. They do fluctuate depending on the rates of plugging and the rates of abandonment.
Okay. All right, we got the sharing portion of this. Could you read that highlighted sentence for us, please?
That says the ranks of these inactive wells grows every year, but that's different from an orphan well.
Okay, I agree. I'm glad you made that distinction. In the reports you cite from 2021 to 2025 that show that the number of orphan wells or wells likely to require near-term plugging, that they've increased, meaning the 2021 report to the BLM and the 2025 LFC report that mentions the 2,100 wells that I just mentioned. Those cite the 2,100 wells are the same in 2021 and 2025, right?
The actual figure from 2021 was 1,741 orphan wells in OCD's submission to the Department of Interior.
Okay. Is that in your testimony?
I believe so. It would take me a while to point to it specifically, but there is a section where I talk about the derivation and justification for the $150,000 figure, and I walk through all the various data points, and that includes the calculation that led to the figure of the average cost of $166,000 per well. That was derived from OCD's total figure of what it estimated it would cost and the number of wells covered. And that number of wells was the 1,741.
Okay. All right. That's helpful. Thank you.
And I believe that submission with the 1,741 figure, in fact, I'm confident, is among the exhibits that was attached to my testimony.
Okay. No, actually, hearing you walk through how you're thinking about them helps me understand, and I'm going to move on to some other questions I want to talk to you about. So let's talk about the inflationary adjustments to bonds that WELC is proposing. In your direct, you state that actual plugging costs increase over time as the costs of materials and labor go up. Is that accurate?
That's accurate, yes.
Okay. Now, in the LFC report that you cite to in your testimony, that report states, and I'm going to quote here, the OCD lacks a systematic cost tracking mechanism, and its procurement processes have contributed to the rapid increase in New Mexico's per foot plugging costs, which are higher than average than neighboring states. Do you recall that text from the LFC report?
Generally, yes. Yeah.
Okay. So if the estimated cost of plugging is already artificially inflated by OCD's systemic inefficiencies, doesn't that mean that the bond rates are already starting from a value that is overestimated?
I think there's different factors here. I think what you're discussing are issues with the administration of contracts. That's an independent cost driver from the costs of labor and cost of materials. Addressing the one wouldn't affect the other.
Well, let me kind of ask you to unpack that a little bit. If OCD's costs to plug and abandon are approximately around 160,000 or closer to the 150,000 that WELC is proposing, and the reason why they're that high is because of their own internal practices, aren't you essentially here asking the industry to meet you at a higher bonding level than you might otherwise if OCD's processes were better?
Well, first of all, as I've previously testified, we did factor in some of that additional cost by using the $150,000 figure rather than the $163,000 figure. I also am happy to stipulate that when contracts are administered by a government entity, they tend to be higher than if those projects were undertaken by a private party. But unfortunately, because it is state regulators who are tasked with plugging these orphan wells, those additional cost overheads are more or less baked into the system.
I get that. And, I think we're all aware the OCD, has limited resources, limited staff, they do the best they can. But by the same token, wouldn't you agree that if we could get OCD's costs, under better control by giving them more resources to implement, then the bonding amounts could essentially be lower than what you're proposing?
Theoretically, although I don't have a figure on exactly what that would be. But again, even if you were to do that, which again sounds like a reasonable thing to do, you would then have a snapshot in time of what the well plugging cost was in that year. And then that cost would grow year over year as the cost of labor and the cost of materials went up.
Sure. Okay. No, I appreciate that answer. Now, in your direct testimony, you state, and this is with regard to financial assurances, if there is a demand for a certain type of financial assurance instrument, the market will fill that demand. Is that accurate?
That's correct. Yeah.
Okay. And so here you're effectively saying that if the commission adopts Welk's proposals, which will require more capital and collateral to be tied up in the bonds, you're okay with this alternative financial scenario for operators in New Mexico?
Could you define what you mean by alternative financial scenario?
Well, I mean, based on your proposals, you're saying that the market will fill the need if your proposals are adopted, right?
I'm saying that I don't agree with the industry witnesses who suggested that a shortage in the surety market would prevent operators from being able to satisfy the financial assurance requirements.
And is this an instance where you would characterize yourself as a surety expert?
Yes.
Okay. Have you ever worked for a surety company?
I have not, no.
Have you ever issued a bond?
I have not, no.
Have you ever issued any other sort of surety?
I have not, no.
Okay. Forgive me, I'm just going through stuff, and I think Ms. Tripp covered some of these things, so sorry if I'm being slow. All right, let's talk about the revisions that were admitted yesterday to 1915-89 NMAC with respect to operating authority. Can you define operating authority?
As I understand it, operating authority would be essentially possession of the permit issued by OCD.
Has Welk proposed a definition of operating authority in its rule proposals?
No.
Do you know how operating authority is different from OCD's definition of working interest owner?
Not specifically, no.
I'm going to read OCD's definition of working interest owner as a preface to my next question. Working interest.
Is it possible for you to put that up on the screen? I don't have that language in front of me.
All right, Mr. Morgan, can you see what's on the screen?
Yes, thank you very much.
Working interest owner means the owner of an operating interest under an oil and gas lease who has the exclusive right to exploit the oil and gas minerals. Working interests are cost bearing. Did I read that correctly?
Yes.
Okay. Now let me also read OCD's definition of mineral interest owner. Can you see the highlight?
Yes, thank you.
Mineral interest owner means a working interest owner or an owner of a right to explore for and develop oil and gas that is not subject to an existing oil and gas lease. Did I read that correctly?
Yes.
So going to operating authority, which is not defined, which requires financial assurance and OCD approval, based upon the definitions of working interest and mineral interest owner in the OCD regulations, that operating authority would apply to working interest owners and mineral interest owners as well, correct?
I disagree. No.
But you haven't defined operating interest. And it seems to me operating interest covers working interest and mineral interest.
I disagree with that interpretation. I think if you scroll down on the page you have up on the screen, we can get to the definition of operator.
Okay. Let's look at that.
And the definition of operator means a person who duly authorized manages a lease's development or producing properties operation, or who manages a facility's operation. I think the inclusion of the term authorized in the definition of operator is adequately specific, that operating authority applies to an operator as defined under the existing regulations. And I think that's a much more appropriate and apt definition than the ones that you just pointed me towards.
Okay. Do you think it would be helpful for there to also be a definition of operating interest as part of this process?
I wouldn't be opposed to that, but again, I don't think it's necessary. And I know multiple parties in this proceeding have objected to the inclusion of definitions for terms that are otherwise adequately defined under the regulation.
Okay. I think Ms. Tripp covered a lot of this that I had. So let's talk a little bit about OCD and how they've been struggling to keep up with plugging requirements, that they face every day in the state using the reclamation fund. Are you aware that there's $66 million in unused funds in the reclamation fund at present?
That's my understanding of the most recent accounting for the funds. Yeah.
Okay. And as part of this proposal from applicants, it seems like one of your main arguments is that the orphan well issue stems from insufficient bonding, not from any sort of administrative efficiency. Is that fair?
No, I think the orphan well problem and the number of orphan wells stems from industry's practice of failing to plug all of the wells that it's required to plug.
Okay, but you're proposing higher bonding to address that, right?
That is one part of the proposal, but the proposal has multiple elements.
Okay. You said in your direct testimony, and refresh my recollection, that OCD has not collected on a bond since I think 2018. Is that right?
That's my understanding, yes.
Okay. Have you provided any sort of analysis to the commission saying that, well, actually, let me back up. They haven't collected on that bonding because I guess the cost of going after that bond is not worthwhile. Is that accurate?
That is my understanding of the reasoning. Yes.
Have you provided the commission any evidence that if they raise this bonding amount to 150,000, that will make it worth OCD's while to pursue that bond?
I think it's generally recognized in the literature that addresses the economics of financial assurances, including in some of the studies cited in my testimony, that when financial assurances are set at amounts adequate to cover the costs of cleanup, that in those instances, regulators will pursue forfeiture of the financial assurance, but that they typically do not when those amounts are set too low.
Has OCD communicated to you that they will definitely pursue the bonds at 150,000 if those are in place?
They have not, no. But I think it's also important to note that, as indicated in my testimony, there are 3 different independent rationale for increasing the amount of a financial assurance. One of them is to cover the regulator's cost to plug the well. But the second one is that adequate financial assurances create an incentive for operators to plug their wells once that plugging comes due, in order to free themselves of the carrying costs in the form of the annual premiums and collateral requirements. And so that is independent of whether OCD forfeits the bond or what it does with it. And then the third factor is inclusion of a financial assurance requirement set at adequate amounts introduces the perspective of the financial assurance provider, in many cases a surety bond provider, which carries out its own risk assessment on the likelihood that an operator will fail to plug a well. So I would say those additional 2 factors are equally important to whether or not, and again, independent from whether or not OCD forfeits the financial assurance.
Well, I guess, the crux of what I'm concerned about here is that if OCD has not pursued a bond since 2018, that means they also haven't pursued the $250,000 blanket bond either, have they?
That would be my understanding, yes.
So there's no evidence, I guess, that you presented that indicates that they're going to pursue the bonding, even if they're raised according to your proposals, correct?
Again, I understand a primary, factor in OCD not pursuing it now is that the amount is so low. So it's reasonable to assume that if that constraint was removed, you would see a change in OCD's decision-making.
But apparently $250,000 isn't the amount that triggers that, right? Not based on recent history.
The per well coverage from a $250,000 bond can be less than $1,000 per well. So you're back in the same scenario of that amount being essentially negligible in the overall cost of plugging those covered wells. So you run into the same dynamic.
Well, let's assume that OCD doesn't collect after you increase the bonding as proposed, because they haven't pursued the $250,000 blanket bond. If they don't, and without some assurance that they will pursue those bonds, then the only effect is going to be to drive up the cost of bonding on industry, correct?
To provide an incentive for industry to plug its wells to then be released from the carrying costs of that financial assurance.
Which OCD may or may not pursue, correct?
The carrying costs to the operator apply independent of whether or not OCD pursues bond forfeiture. A surety company charges a premium and sets collateral requirements regardless of whether OCD ultimately forfeits that bond. Those decisions are made at a point much earlier in time to when a forfeiture decision would be made. So that dynamic is in place regardless of OCD's activities.
But as proposed, there's no mechanism to require OCD to pursue a bond, correct?
That's correct.
All right, I have one more topic I want to talk to you about. Yesterday in your direct, you talked about the W&T litigation, is that right?
That's correct, yes.
And you said that you've been following that pretty closely.
Yes.
So as someone who's been following it closely, you're aware that in June of this year, W&T settled with several of the defendants, including the U.S. Specialty Insurance Company?
Yes.
Okay. And that settlement announcement is attached as Appendix F to the Emmerich rebuttal testimony. Did you get to review that?
I did, yes.
Okay. And document 141 in the settlement order, which is attached, that was in the Southern District of Texas. Did you see that?
I can't say specifically.
Would it be helpful for us to pull up Emmerich's exhibits?
I would appreciate that.
Okay.
Thank you. I don't have them in front of me.
It's a settlement. All right, does the document that's on this, sorry, it's not up. Does that document look familiar to you based on your review of Emmerich's testimony?
Generally, yes.
Okay, so do you agree that that's a settlement?
It's a motion for entry. And actually, no, I don't recall this as being the settlement. This refers to a docket control order.
Sorry, scroll down. There it is. All right, does this look to you like the settlement order from the Southern District of Texas?
It's the order granting the motion to dismiss.
Okay. So yesterday you cited defendant Lexon's motion to dismiss, which was granted, right?
I don't believe the motion to dismiss has been ruled on.
Okay, so it wasn't granted. But you cited to the motion, correct, in your slide?
Yes, I cited to Lexon's motion.
And you read it as if the case had already been decided, which it has not, correct?
Absolutely not. No, that was not my characterization. Mr. Emmerich had relied on the complaint filed in the matter to characterize the surety's motivation. I read the surety's statement as proof of the surety's characterization of their motivation in requiring the additional collateral. So I did not indicate, nor did I intend to, that was an order in the case. It was speaking only to the surety's own words, describing their motivations to counter Mr. Emmerich's quoting of the defendants in that matter, characterizing the intent of those sureties.
Okay. But you're aware that this case is proceeding to jury trial, I think in February of 2027?
That's my understanding, correct?
Okay. And at that trial, is it your understanding that's when the disputed facts as to whether or not the overhaul of federal onshore financial assurance triggering the $12 million collateral demand will be determined?
I don't know if that will be one of the specific matters determined. The case involves alleged antitrust activities by the sureties. That's the question that will be put to the jury.
Would you agree that the outcome of this case could be a harbinger of what might happen in New Mexico if your proposals are adopted?
It's difficult to say. This W&T matter involves surety bonding for offshore oil and gas operations. And the dollar amounts of the surety bonds at issue there are orders of magnitude greater than those required for onshore wells, in the hundreds of millions of dollars for a single operator, or even in some cases for a single facility. And the economic factors impacting offshore oil and gas development are quite different from the economic factors applicable in New Mexico.
Okay.
Mr. Suazo, you have 5 minutes.
I have no further questions for the witness, Madam Hearing Officer. Thank you so much.
Perfect. We need a 15-minute break. Let's come back at 11:05, please. please. All right, we have Mr. Morgan back in his seat. Mr. Sayer, do you have questions of Mr. Morgan? Thank you. Mr. Sayer said no. Mr. Rankin, do you have questions of Mr. Morgan?
Good morning, Madam Hearing Officer. Thank you. I do. Morning, Mr. Morgan.
Good morning.
Mr. Morgan, just for purposes of clarification, you don't have any experience working directly in the oil and gas industry itself, do you?
I do not know.
And you never worked for an attendant industry, like you never worked for an oil and gas service company or anything that related to oil and gas industry?
I have not, no.
Then you're not qualified to testify as an expert in petroleum engineering, right?
Absolutely not.
Okay. We'll get into the discussion around the statutory authority. I'm going to go ahead and share my screen as I walk through this with you. So this is your direct testimony, and it's page 4. And I've highlighted some language here, and this testimony here, you're referencing the one well financial assurance provisions, correct?
That's correct.
Okay. And you're referencing the statute that governs that provision, right?
Correct.
Okay. And you agree here, I'm going to go ahead and pull up the statute. The language that you were referencing in particular was the language in purple, correct? The one well financial assurance.
That's correct.
And you agree that the statutory command that financial assurance be set in an amount sufficient to reasonably pay the well's plugging costs applies only to the one well category of plugging bonds, correct?
I'm not sure that's correct, no.
Okay, so so your interpretation of this is that the language is not limited to the one well. The language in purple here is not limited to the one well financial assurance plugging.
I believe it's most directly applicable there, but I'm not sure I'm comfortable saying that it's exclusive to that.
Okay. So you believe that, let me just ask, I mean, how could it be applicable to the, let me ask you this then. Is it applicable to the active well blanket bond?
I mean, it's all one sentence, and that phrase comes at the end of the sentence. And so I can't sit here and say that it only applies to that final clause and not to the preceding clauses as well.
Well, let's just talk about this. I mean, could the division then go through a rulemaking and determine that the blanket bond should be more than the statutory limit?
I mean, again, I think it's clearly applicable to the one well plugging financial assurance. Its applicability to the others, I think, is less clear, but I'm just avoiding making a definitive statement as to its applicability to those earlier.
I'm going to push you to make a definitive statement as to the blanket active plugging bond. Okay. Is there any circumstance that you can conceive where that purple language could be applicable to the statutory limit of $250,000 so that the division could make a higher limit to apply to the statutory blanket plugging bond?
As phrased that way, no.
Okay. So
Mr. Rankin, I'm
Yeah.
very sorry to
Yeah.
interrupt. The court reporter has her hand up, and I feel like I
Oh.
need to ask why.
Probably should.
Ms. Smith, can you unmute yourself? Or Sheila, could you establish perhaps a phone connection with her so that you could do this offline?
Yes, we'll do that.
Very sorry about the interruption here, but we are making a transcript. Okay.
No problem. While we're waiting, I didn't start my timer, Ms. Hearing Officer. Where are we at on time? already?
You were 5 minutes.
5 minutes in, okay.
Sheila, where are we?
All is well. I spoke with the court reporter and she was just wanting to alert us that she was back from the break. That's why her hand was.
Okay. Well, thank you very much. Maybe just establish an off-channel
We've done that now, yes.
line of communication
Yeah.
with her. Thank you
Done
so
that.
much.
Thank you.
All right. We are back from a break, and Mr. Rankin, you have 40 minutes.
Thank you, Madam Hearing Officer. Mr. Morgan, where we left off, I think you just agree with me that the language in purple on your screen here is not applicable to the language in green because the language in green, it sets a statutory cap at $250,000, thereby establishing that the commission or division doesn't have authority to change that based on the amounts required to plug a well, right?
That's correct.
Okay. So based on that, you would agree with me that the blanket bond under the statute was not intended to cover the actual costs of all wells an operator operates. Agree?
That where the regulations include a blanket bond, that, yeah, it must be capped at that 250,000 and therefore wouldn't necessarily be adequate to cover the cost of plugging the wells.
And that's the point you make in your testimony, in your direct testimony on pages 28 and 29, where you identify the existing regulations and the one well financial assurance under the existing regulations. And then you go on to say at the top of page 29 that the current blanket bonding provisions allow for significantly lower financial assurance amounts, correct?
That is the text, yes.
But the point that you're making in this paragraph is that because the blanket bonds aren't intended to cover the actual costs of all the wells, the per well amount is actually can be far less depending on how many wells are under that blanket bond, correct?
That's correct.
Right. Okay. And then further down on this page, you note and identify that OCDs acknowledge that because of these statutory limits on the financial assurance, the amounts available for forfeiture are typically below plugging costs. Agree?
Correct.
Okay. Okay, so we had this up on the screen, the actual statute, and we talked through the language in green. I'm gonna just real quickly touch on the language in blue here. So there's basically sort of, three categories or three sort of portions set out here. The first one we talked about, which is the blanket bond for active, and you agree with me, that's for active wells, correct?
That language isn't specified in the statute.
You agree, you don't agree that it covers the active wells?
I agree that under the current regulations, it is applied to active wells, but there's nothing in the statutory language that restricts it.
Okay, so then the next category I want to talk about is the temporarily abandoned status wells in blue. And that statute, the language of the statute provides for a blanket plugging financial assurance for temporarily abandoned status wells, which shall be set by rule at amounts greater than $50,000, correct?
That is the text, yes.
And rather than setting a maximum, the statute sets a minimum blanket bond for TA status wells, agree?
Correct.
And it has to be at least $50,000.
Yes.
And so therefore it gives the division discretion to set what the maximum might be, correct?
Yes.
And that makes sense because based on your own testimony, these temporarily abandoned wells are potentially the most risky, right?
Yes.
Okay.
Well, among the most risky.
Among the most risky, okay. But the legislature did not set a, so here, the legislature is clearly distinguishing between temporarily abandoned well status wells and active wells or wells that are otherwise subject to the statutory blanket bond cap. Correct?
Yes, although I feel like I need to point out that the language here, the sentence you've been quoting from starts with such categories shall include, but is not, I read that as saying it's not limited to that. So these are examples of categories, or these are the minimum categories required, but these aren't the only categories authorized or required.
Right. I understand. When you were testifying with Ms. Tripp, I believe you agreed that there were, under the statutory framework, that there were active wells and inactive wells, right? For the financial assurance.
I believe that was when we were discussing the regulatory language, not the statutory language.
Okay. So, but just as to my question, the legislature clearly distinguishes here under the statute between temporarily abandoned status wells and these other category of wells that are subject to this blanket plugging financial assurance, correct?
Yeah, the only specific well type identified in this statutory language is the temporarily abandoned status wells, which is highlighted in blue.
And the distinction that the legislature makes as to those wells is that it sets a minimum for a blanket bond for those wells, whereas it sets a cap for all other wells that would fit under the blanket plugging financial assurance, correct?
I disagree. I read the language you have highlighted in green as saying that among the multiple categories that the division shall establish, there has to be a blanket financial assurance capped at $250,000 available. But it doesn't say that that's a catch-all to which all wells other than temporarily abandoned status wells could qualify. It's just, there has to be a category that checks that box, but it could be a more limited category.
Okay, and you agree with me that it has to be made available, correct? That's what you just said.
There has to be an option for some wells that includes a blanket financial assurance at $250,000. Yes.
Okay. Then the third one is the one that I think you're focused on with your proposal, or with the applicant's proposal, and that's for the one well plugging bonds, right? And that provides that financial assurance for one well bonds need to be in amounts determined to be sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance, correct?
Correct.
Okay. So and in this instance, for this one well plugging bonds, there's no maximum or minimum set by statute, correct?
That's correct. Yes.
Right. And that's for the one well bonds, right?
Correct.
And that provision in purple applies to one well only, right?
The language you have highlighted in purple includes the language that addresses the one well plugging financial assurance. Yeah, but I'm not sure all the language you have highlighted in yellow is limited or specific to applying only to the one well plugging financial assurance.
So let me just be clear. I'm asking you about the language in purple here, okay? The language in purple that I read to you applies only to one well, correct?
Yes.
Okay. So the authority for the division to set reasonably sufficient amounts for wells for financial assurance applies to one well, right?
Again, I don't accept that characterization that the language talking about the amount being sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance is specific to the one well plugging financial assurance. I believe that language could be applied to the language in yellow applying to the other categories that could be required.
Okay. Very well. Now, this is the provision that applicants are relying on to create the marginal well financial assurance category that's being proposed in this rule, correct?
That language applies to that. I'm not sure that's the only language that's being relied upon.
What language are applicants relying on to create the proposed category of marginal wells?
I believe, again, that's the language in yellow specifying that the list of categories here is not exclusive and inviting regulations to specify additional categories.
So if I were to ask you, or I'm going to restate or rephrase to narrow what you're telling me, if I say that what the language that applicants are relying on is the language in yellow that I've highlighted here, the Oil Conservation Division shall establish categories of financial assurance after notice and hearing. Such categories shall include, and then I'll continue to the purple language, one well plugging financial assurance in amounts determined sufficient to reasonably pay the cost of plugging the wells covered by the financial assurance. Is that the language that I just read that applicants are relying on to create the marginal well category?
The language in yellow, yes.
As well as the language in purple?
That is, yeah, referenced as well. But again, that's the language in purple is not the exclusive authority being relied upon.
So I'm just trying to get you to tell me, okay, what is the language? Is it the language in yellow and purple? Is there any other language on this statute that you're relying on that I didn't reference?
I don't believe so. I think it's the language in yellow and purple.
Okay.
There.
So using those two portions of the statute, the rule proposes to create a new category of wells for financial assurance that's a marginal well, correct?
Correct.
Okay. Now, I want to ask you about the bond, the blanket bond, okay? The $250,000 blanket bond in green. Could it be the reason that the legislature set a statutory limit of $250,000 under that provision was that it's trying to balance the financial burdens on operators to avoid potentially reducing ultimate recovery?
I'm not going to speculate as to the reasoning of the legislature.
Okay, but you're testifying as an expert in policy, especially on financial assurance. Do you have an understanding about why the legislature might have chosen to do that?
In a theoretical sense, but I have no insight into the actual reasoning or motivation of the legislature in this instance.
Okay, so you can't tell me, based on policy, for policy reasons, why they might have chosen to set a cap at $250,000 in this instance?
No.
Objection, speculation.
Right. I think you were inviting him to speculate, and I think he just declined to do that.
Well, I guess I was trying to ask him about, as an expert in policy, what his understanding of a reason that a legislature might do that. So I'm not asking him to speculate what the legislature might do. I'm asking him in his capacity as an expert in policy, why that might be the case, why a legislature might do that.
Right. You're inviting him to speculate about why the legislature might have done something.
Okay. I'll move on. As I understand your testimony, Mr. Morgan, I think I understand you to argue that this new category, marginal wells, can be essentially carved out from what would otherwise be applicable for financial assurance coverage under this $250,000 blanket bond. Is that correct?
I don't believe it's a carve out because, again, that language highlighted in yellow invites the creation of any number of categories.
Sure, but without creating that new category, they would otherwise be applicable to that $250,000 statutory limit, correct?
Only if the implementing regulation directly copied the specific language of the statute. But again, the statute empowers and invites the commission to create multiple categories of financial assurance, only one of which is a $250,000 blanket bond.
As things stand right now, all wells that are subject to this marginal well financial assurance would otherwise be subject to this $250,000 cap, correct?
Under the current regulation, correct.
And the current statute, correct?
No, because again, the statute invites rulemaking to set any number of categories. In this instance, that rulemaking is as you described, but the statute doesn't put limitations or specify which wells would be covered under the blanket bond that's available under the statute.
Sure, but setting aside the fact that there hasn't been any further regulation, just reading the statute by itself, all these wells that are being proposed as a new category marginal wells would otherwise fall under that $250,000 statutory cap. Agree?
Again, that's not how I read the statute. The statute is providing examples of the types of categories that could be promulgated under regulation, but doesn't limit it to only the enumerated categories.
Sure. What category would these wells fall under the statute as you read it right now?
The marginal well,
No, current wells before currently as it exists right now. The regulations and rules exist right now.
under the current regulations, they could qualify for the $250,000 blanket bond.
Okay. So the statute here, and I'm going to read the part in yellow, okay? The statute states that the commission shall establish categories of financial assurance, and it goes on to say that those categories shall include a blanket plugging financial assurance. Agree?
Yes,
Okay, and when the statute uses the phrase shall include, doesn't that suggest that these are mandatory categories that must be made available to operators?
mandatory but not exclusive.
Right. So I'm going to go to your slide 6, okay, from your demonstratives. This is where you're outlining the new financial assurance approach for this new category well under 1915-8-9D, correct?
That's correct.
Okay. Starting in January 2028, operators will be required to provide a one well plugging bond for each marginal well, correct?
Correct.
And then even though, okay, now let me ask you this. You agree with me that marginal wells are active producing wells, agree?
Yes,
Okay, so even though marginal wells are active wells and they're producing, operators would not be able to rely on the $250,000 blanket bond to cover marginal wells anymore going forward, correct?
that's correct.
Okay, and then if an operator has 15, and I'm looking at subparagraph 3 here, if an operator has 15% or more marginal wells or inactive wells or some combination in their portfolio, they have to provide plugging financial assurance in the amount of $150,000 for each well they operate, even if those other wells themselves are not within the category of marginal wells. Agree?
That's correct. Yeah.
Okay. So you call this new one well plugging category, right? You call it a new one well plugging category in your testimony, but under the proposed regulations, they're being applied to multiple active producing wells. Agree?
Yes, but the financial assurance amount is calculated on a per well or one well basis.
Okay. So therefore, as many wells as an operator has that qualify as marginal, that operator then has to pay $150,000 per marginal well, right?
They have to provide a financial assurance in the amount calculated based on $150,000 per well.
Okay. So just to be clear then, the rule also prevents operators with more than 15% marginal wells or inactive wells or some combination from using the standard blanket bond for its financial assurance, correct?
That is correct.
Okay. And that's true even for wells that do not fit the marginal well category, agree?
Once that 15% threshold has been exceeded, yes.
Okay. So in fact, the proposed rule prevents operators from using the blanket bond as a financial assurance for any well when an operator has more than 15% marginal wells in their portfolio. Agree?
That is correct.
Okay. And in that situation, all active wells in the operator's portfolio then are subject to the $150,000 marginal well financial assurance. Agree?
That is correct.
Okay. So I want to make sure that I'm getting it right. So by creating a one well bond category for marginal wells, correct? That's what's happening. At the same time, then the proposed rule under 1915-8-9D forces operators to combine non-marginal active producing wells with a new category of marginal active wells and treats both categories as if they're one and the same and all subject to the one well marginal financial assurance when they have more than 15% wells that are either marginal or inactive. Agree?
I would characterize it slightly differently. I would characterize it as creating a new category that encompasses all of those types of wells that you described.
But you're combining one category, you're defining one category as marginal wells, and then you're grouping a whole bunch of other wells that don't meet that category in the same financial assurance requirement. Agree?
Again, the specific mechanism is through creation of a new category.
But these wells that you're including don't meet that category, do they? All these other active producing wells do not meet the definition of a marginal well, do they?
They do meet the category because the category is defined at D3 as encompassing all of those wells.
Interesting. Okay, so then the proposed rule not only treats marginal wells as if they're in this newly created marginal well category, right? But those non-marginal wells that are actively producing can no longer be covered by the blanket bond that would otherwise be applicable to them, right?
That is the effect.
Yeah, so what happened to the blanket bond? That's required by statute to be available to operators.
The blanket bond remains available for operators of active wells that do not fall into the newly defined category.
Okay, so the newly defined category includes essentially all active wells where they have more than 15% marginal wells in their portfolio. So it basically eliminates the option for those operators to rely on the blanket bond, correct?
Correct, but any operator who has active wells with marginal and inactive wells representing less than 15% still have the option of using the $250,000 blanket bond.
So, okay, so, but as to those operators that fall in this new category, this new expansive category, doesn't that make the existence of a statutory well bond, a statutory blanket bond meaningless if the commission can go forward and approve rules that simply prohibit active wells from being covered by the active well bond?
No, the statute merely requires that among the categories available to operators be a category that includes a $250,000 blanket bond. And under the proposed amendments, there is still a $250,000 blanket bond available to certain operators. In addition, there are other categories that apply to other operators or other wells. So the statutory requirement is still satisfied because there is still a $250,000 blanket bond available.
Well, I can come up with scenarios where, based on creating new categories, that blanket bond becomes available to like maybe one operator, and therefore becomes almost meaningless. So here, let's just talk about a couple examples, okay? But before I do, let me just ask you, just so I'm clear, okay? Under applicant's rule, the proposal would require operators to post $150,000 per well bonds for what could be hundreds of non-marginal active producing wells, simply because more than 50% of their portfolio constitutes marginal wells or inactive wells or some combination. Agree?
That's correct.
Right. So an example on the low end, for an operator with 5 wells, that includes one marginal well, and their current $50,000 bond under the existing regulations suddenly becomes $750,000, right? Because they've got 5 wells that are, and 15% of those wells are considered to be marginal, right?
Yes, but that's only true if in the time between when the rule is finalized and January 1st, 2028, that operator doesn't avail itself of any of the options that would reduce its marginal well count below 15%. That would be returning that well to production above marginal well status, plugging the well, or selling that well to another operator.
Sure, but in between, another well might come up. They say they had 5 wells in one. Anyway, there's various options, scenarios that could arise. But the point being that at the time this rule becomes effective, an operator with 5 wells, and one of which is marginal, their plugging bond financial assurance is going to go from $50,000 to $750,000. Agree?
If they don't avail themselves of those other options before that deadline, yes.
So that would be an increase of 15 times their financial assurance requirements, right?
That would be the face value of the financial assurance, yeah.
Okay, and that would be 3 times the legislatively set maximum blanket bond. Agree? It would be 3 times above the legislatively set amount of the blanket bond. Agree?
It would be 3 times $250,000. Yes.
Okay. So Mr. Purvis's testimony was that most wells reside in large companies with portfolios of 400 wells or more. Do you recall that testimony?
Not specifically.
Okay. Do you dispute that was his testimony?
I can't say one way or the other. I don't have that in front of me. I'm sorry.
It's okay. That's my job. So here I'm showing you testimony from Mr. Purvis's direct testimony where he says that, oh, I'm sorry, I'm not sharing yet. I apologize. Here I'm showing testimony from Mr. Purvis's direct testimony, pages 38 and 39, where he says that the change in the increase in the blanket bond under the regulations would not have wide effect because most wells reside in large company portfolios of 400 or more wells or more, thereby allowing them to be qualified for the blanket bond. Do you see that testimony?
I see that fragment, yes.
Okay. So if most companies have 400 wells or more, and they have, say, one of those companies has 400 wells with 15% marginal wells, their financial assurance would be 400 wells times 150,000, which would be $60 million, right?
For operators with that number of wells, with marginal or inactive wells exceeding the 15% threshold. But as I understand Mr. Purvis's testimony, that applies to 18% of wells or 2.3% of production in the state.
Okay. So, but nevertheless, as to those operators, you know, I'm not going to dispute your recollection, but as to those operators, that would be their financial assurance requirements, right?
Again, if they decline to avail themselves of the various options to reduce their percentage below 15%.
Okay. So, you know, with 400 wells, say they're right at the 15% cusp. Okay. They got 15% of their wells being marginal, and they have 400 wells. Suddenly, all the other wells that are active producing wells are being treated as marginal wells, and they're having to pay $150,000 per well, right?
No, they're not required to pay $150,000 per well. They're required to provide a financial assurance calculated based on $150,000 per well.
So sorry, I misstated, but that's what I intended to say. Apologize. Thank you. Okay, so that's the instance for that group. Now, the proposed rules treat all operators the same, right?
Correct.
And if they have, no matter who they are, what their history is, if they have more than 15% marginal wells in their portfolio, then all operators have to meet this enhanced financial assurance requirement under the new rule, right?
That's correct.
Okay. It treats them the same no matter how effective they've been at staying in compliance with OCD's inactive well rules or any other compliance issues, right?
That's my understanding, yes.
No matter how effective they've been at plugging their wells to date, right?
That's correct.
So you and I'm going to circle back here to the statutory issue. So my understanding is that when the legislature, your opinion is that when the legislature set the $250,000 statutory limit for blanket bonds, your opinion is that it is intended to allow the division to circumvent this cap by creating new categories of financial assurance.
Again, I'm not willing to speculate as to the intent of the legislature. I will say, in the way they drafted the statute, they required a blanket bonding provision with a $250,000 cap at the same time that they authorized the creation of any number of additional categories.
Okay. Now, were you aware of whether or not applicants were involved in trying to get that limit amended by the legislature previously?
I'm not specifically aware of that. I wasn't involved in any such efforts.
So under this approach, okay, by creating new categories that are not exclusive, right, under the statute, nothing would stop the division or the commission from creating new categories, say for stripper wells, with a $300,000 per well $300,000 per well bonding requirement, correct?
Not if they satisfied the other requirements of the statute in justifying the creation of that category.
So the division could create a new category for stripper wells, could require an operator to provide $300,000 financial assurance for each well in its portfolio if more than 15% of its wells were stripper wells, right?
Theoretically, but again, that would have to go through a notice and hearing process, and that figure would have to be justified.
Sure, and it could do the same thing for horizontal wells, right? Going forward in the future, correct?
As I read the statute, there's no limitation specified as to the type of category or number of categories other than the requirement that it go through a notice and hearing process.
So under the applicant's approach, in 15 years, when we start to see horizontal wells run their course, according to Mr. Purvis's testimony, nothing would stop the division from creating a new financial assurance category for horizontal wells with per well bonding requirements of, say, $500,000 or more for each well, as long as they can establish the basis for that cost, correct?
If that were justified based on the record following the notice and hearing, theoretically, yes.
Okay, and then OCD then could require an operator to provide $500,000 for each well in its portfolio if more than 15% of its wells were horizontal wells. Agree?
I mean, this is all very speculative. I feel like I've already addressed the limits that would apply to such a rulemaking.
It's not speculative. I'm just taking your approach and applying it, taking the logic out, okay? To
Objection, asked and answered.
Yeah, Mr. Rankin, you keep asking him what could happen, and it is
Okay.
speculation.
Well, I guess my point is there's nothing stopping based on applicant's approach, there's nothing stopping the division from creating new categories with higher amounts that undermine their operators' ability to make use of the statutory $250,000 statutory financial assurance obligation, correct?
Other than the requirement that follow a notice and hearing process and therefore be justified based on the facts in the record.
So there's no limit to the potential carve-outs from that blanket bond cap that could be possible simply by creating new categories of financial assurance, correct?
Objection, asked and answered.
It's been asked and answered
I don't
twice
think so. I
now.
think I'm asking him to summarize his testimony to make clear. I don't believe I asked that question before. I've asked him about different categories, and I'm asking him now to confirm that there's actually no limit to what the division or commission can do in terms of what kind of rules it can propose.
He's already answered that same question in different words twice now.
As long as the record's clear that he agrees with me that there's no limit to what the division can do, then that's
Would you move on, please?
Let's see here. Just want to ask you a couple questions about the LFC report. This is applicant's exhibit 4. At the bottom here, Mr. Alexander highlighted this language in red, in bold, and it says that the statute requires operators to provide financial assurance to OCD before drilling to insulate the state from well plugging and reclamation liability, but the maximum allowable amounts do not cover actual costs. Did I read that correctly?
That is the text, yes.
Yeah. Do you agree with the Legislative Finance Committee statement here that the current maximum allowable under the statute is the blanket bond amount of $250,000?
No, I do not.
Goes on to say on the next page that I've highlighted this in orange. However, the statute caps total financial assurance at $250,000 per operator for all active wells, even though plugging a single well can often exceed $100,000, and most operators in the state have more than 5 wells. Did I read that correctly?
That is the text.
Do you agree with the LFC on the statement that the statute caps the total financial assurance at $250,000 per operator for all active wells?
I do not.
Now, Ms. Tripp asked you this question, but I'm going to ask you in a slightly different way, okay? But when we look at, based on all that's reviewed in this LFC report, okay, the LFC, the committee comes back with some recommendations. She pointed this language to you, okay, that I've highlighted here. So the LFC concludes its report with a series of recommendations, and including the recommendation that the legislature amend the Oil and Gas Act financial assurance provisions to provide that low producing wells require additional financial assurance. You agree that's their recommendation, right?
That is the text.
Okay. And that's because the statute clearly caps the total financial assurance at $250,000 per operator for all active wells. Do you agree?
No,
But that's what the LFC believes, correct?
that's consistent with the text that you highlighted.
Okay, so your understanding is the LFC believes that the statute needs to be amended to affect that change. Agree?
I can't, based on the prior language that you highlighted, I think the LFC had a misapprehension of the limitations placed under the statute. I can't say the extent to which that misapprehension informed this specific recommendation. And as I said in my testimony earlier, they do not say that only a statutory change would authorize the type of changes proposed in this rulemaking. They recommend a legislative change, but they don't say that that's the only avenue through which the bonding levels can be changed.
Mr. Rankin, you have 5 minutes.
Thank you. So just to be clear, I think my understanding is that you disagree with the LFC's interpretation of what the statute provides or any limitations created by the statute on the division. Agree?
Yes.
Okay. I just wanted to also say, and I meant to say this at the outset, Mr. Morgan, but I was a little worried about my time. But I wanted to point out that you point out in your testimony, as do other witnesses for the applicant, that based on negotiations with Oxy, you have reached certain agreements and adopted some of Oxy's proposed language, correct?
That's correct.
And given my time limitations, I'm not going to walk through all those, but you identify each of those in your rebuttal testimony, correct?
I believe so. I believe that's where we identified them.
And I just because of time limitations, I won't walk through all those, but I appreciate your acknowledgement and engagement with Oxy on those issues. And I just want to make sure that was clear for the record. Despite my pointed questioning on the marginal well issues, we do appreciate your engagement with us on the other aspects of the rule. So thank you.
Thank you. And likewise, we appreciate the opportunity to negotiate those issues with Oxy and Oxy's willingness to agree to that language.
Appreciate it. And the negotiations continue. With that, Ms. Hearing Officer, I have no further questions of this witness and make them available for other questions.
Thank you very much, Mr. Rankin. It's 11:57, so I'll call on the rest of the parties for their questions after we've had a lunch break. Let's come back at 1.